Okay, then. So it's a little after 1, so let's get started. First of all, welcome. And my name is Jason Mazzoni. I'm a professor here at the University of Illinois College of Law. And it's my pleasure to welcome you to today's Constitution Day event. September 17 is the date in 1787 in which the delegates to the Philadelphia Convention sign the proposed Constitution, and the convention is adjourned. But that isn't the end of the process. It's, in a sense, it's just the beginning, because then the Constitution goes to the states for ratification. Congress has designated September 17 Constitution Day, and we don't get the day off. In fact, there's an obligation. Educational institutions that receive federal funding, such as ours, are required to hold an educational program observing the day. Not that we need incentives to talk about constitutional issues, but this is an extra nice one. And so every year on this date, we hold an event. And this year, with a presidential election coming up, we thought, what better topic than to focus the program on than the presidency? And when we decided that, we knew immediately the best person to invite as our speaker. Professor Saikrishna Prakash, who joins us today from the University of Virginia, is a leading scholar of the presidency. He's been studying and writing about the presidency for many years. And you really can't write about the presidency now without engaging with his important work. In fact, I can say from personal experience that sometimes you think about writing about the presidency and realize that he's already written the thing you're thinking about writing. The timing is also especially opportune because Professor Prakash has a book published just this year by Harvard University Press called The Living Presidency, with the subtitle An Originalist Argument Against Its Ever-Expanding Powers. Here in Illinois, we care a lot about presidents and the presidency. When I'm recruiting students, I tell them, oh, sure, you can go to UVA to study the Constitution of Madison and Jefferson and other Virginians, but our Constitution today is Lincoln's Constitution, so you're better off coming here to Illinois. But we'll see what Sai has to say about President Lincoln. The book is a wonderful read. It's filled with provocative insights about the office of the presidency and about particular presidents, and also has some very interesting proposals for reform. It's also reasonably priced for birthday or wedding gifts, and there's only 98 shopping days until Christmas. We even have a book giveaway today. 10 audience members, you had to register in advance and also be here, will receive a copy of the book based on a lottery. We'll be in touch with the winners after the event to get them those books. Professor Prakash is going to speak for a bit and then answer questions. I think the easiest thing will be for our audience members to enter their questions into the chat box, and Vic Amar, who is here, and I will monitor those and pitch them to Professor Prakash. Try to cover as many of them as possible. I'm sure Dean Amar and I will probably have some questions of our own as well. The event is, at least right now, being recorded. So just make a note of that. And to minimize background noise, as always, please be sure you're on mute. With that, Sai, thank you so much for joining us. It's a real pleasure to have you here.
Oh my gosh, Jason, it's my distinct pleasure and honor to be here with you folks. This is, after all, Constitution Day. When Jason reached out to me and asked if I could do this, if I would do this, I immediately said yes before he could change his mind. So this is just a great treat for me to be here with you virtually. And as Dean Amar said, I've got a long-standing tie to University of Illinois College of Law. I was a visiting professor there about 20 or 25 years ago. I'm happy to see Tom on the Zoom call. I can't see everybody at the same time. I'm gratified that we have 3 pages of Zoomers. And, you know, we lived in Urbana when we were out there. I still remember various places like Meijer grocery store. I really liked Meijer for some reason. It was a wonderful experience, and you know, great faculty and excellent students. So I'm very happy today to be talking to you about this book, The Living Presidency. Jason has said that some of you will get a free copy, but let me say that, you know, sometimes purchasing things yields more satisfaction because you feel like you've done something to earn it besides listen to me prattle on. It's available on Amazon. Operators are standing by. The book is sort of a bookend, I guess, if that's the right word, to another book I wrote. I wrote a book about 4 or 5 years ago with Yale Press called Imperial from the Beginning, the Constitution of the Original Executive. And the idea was to write a soup to nuts book on the original presidency and discuss all the powers of the original presidency, why it looks the way it does, and then the limitations on the original presidency as well. And, you know, I talked about law execution, foreign affairs, war powers, privileges and immunities, and various other things. But one of the chapters was about why people drew comparisons to a monarchy when they looked at the presidency. And it turns out a lot of folks did this. Of course, the Anti-Federalists said that the presidency in the Constitution was basically a monarchy in all but name. But it wasn't just opponents of the Constitution who said this. There were other people as well, some of whom favored the Constitution, and other people that were just observers, either at home or abroad. So you had people like Jefferson, William Short, his advisor, John Adams, the Dutch stadtholder, all say that the presidency resembles a monarchy. We can't see this today because our president doesn't have a crown, doesn't have a palace, or kind of does, but we don't call it a palace. It's the White House. Doesn't have a crown, doesn't have a scepter, doesn't have a throne, doesn't have, you know, purple robes. And then we think of monarchy, we think of absolute monarchy. And then we don't think that monarchs are elected. But it turns out in the 18th century, they had a different conception of monarchy. They knew there were such things as limited monarchies. The English monarch or the British monarch was a limited monarchy, but it was not an absolute monarchy. You had to go to France to find that. They also knew something about elected monarchies, right? The papacy was an elected monarchy. Think of the Papal States and think of the College of Cardinals. The Polish monarchy was elective as well. They had a huge college of electors, numbering in the tens of thousands. The Holy Roman Empire, emperor for a time was an elective monarch. And so they did not believe that that all monarchs were hereditary or that all monarchs were absolute. And when these folks looked at the Constitution, they saw a president that was far more powerful than the presidents that had preceded, the executives that had preceded the presidency in America. What do I mean by that? Well, if you looked at the state executives or the federal plural executive in the form of the Continental Congress, they were weak by comparison. State executives had limited appointment authority, had no foreign affairs authority, typically had no pardon authority, and typically had no share in the legislative power. They did not have a veto. Furthermore, most executives were term limited, often to 1 year, and were plural. That is to say, they had executive committees rather than a unitary executive, right? So Pennsylvania had an executive council, Virginia had a governor that was hemmed in by an executive council. And so they didn't have the sort of unitary powerful figure that the Constitution contemplates. And so when you think about the background in the 18th century, the late 18th century, you can see why so many people thought you have a monarchy, you have a king in all but name. And even someone like Montesquieu can be cited for this proposition. Montesquieu said of the British system, he said, you have a republic disguised as a monarchy. Because he looked at that situation and he said, this king is not absolute in any way. It's not a pure form of a monarchy. It's what people in the 18th century would call a republican monarchy. And in fact, people did talk about the idea of a republican monarchy, which blended together elements of republics and elements of monarchies. So the book describes the original presidency, and even though many people thought of it as monarchical in some respects, it wasn't an absolute monarchy, and there were various constraints on the executive. One was that the president had a check on the laws, but once made, he had to execute them, right? The president has a duty to take care that the laws are faithfully executed. And so once a bill becomes a law over his veto, he's got to execute it, and so do his successors. A second constraint is that the president had to preserve, protect, and defend the Constitution, which meant he couldn't amend the Constitution via practice or otherwise. And if you look at Article 5, there is no presidential role with respect to the proposal or ratification of amendments. Now, that's a little too cut and dry. The president can make recommendations to Congress, right? And he can make legislative as well as constitutional recommendations. But amendments don't need to be presented to him, and he doesn't need to approve of their being sent on to the states. And really, it's not even obvious that he has any role in deciding whether the amendment was ratified, right? The Article 5 talks about how amendments are ratified, but doesn't specify who decides. So there were these important constraints on the executive, as well as other constraints, like the president could not declare war. The Constitution doesn't say he can't declare war, but it's an implication of the grant to Congress that the president can't declare war, just like the Chief Justice can't declare war, right? It doesn't say that, but we can infer as much. And so, the president could not start wars in the 18th century. He could not make treaties without the Senate's consent because, of course, it says that he needs 2/3 of the Senate's consent. If you flash forward to today, this presidency no longer exists. It no longer exists. And let me tell you why it no longer exists. Because presidents, through practice and acquiescence or forgetfulness on the part of the public, have acquired new sorts of powers that were not with the presidency at the founding. So let me take the example of war powers. Modern presidents today claim the authority to start wars, to wage wars against foreign nations. And they do this in the face of the Declare War Clause. And they cite the example of Harry Truman in Korea, but they cite a bunch of other presidents as well, like Reagan, Clinton, now Obama, and maybe now Trump, right, with respect to the Syrian airstrikes and the targeting of Soleimani. And so modern executive branch lawyers say practice has put a gloss on the Constitution. The president can use military force in various ways, so long as it doesn't rise to a war. And what they mean by that is not entirely clear, because sometimes they're citing the Korean War, and I guess they're saying that that's not a war. Most of us think it was a war. Hundreds of thousands of US troops were involved, millions of troops internationally were involved, hundreds of thousands of casualties amongst the combatants. So it seems sort of silly to hold on to the view that this was some sort of police action rather than a war within the meaning of a constitution. The end result is that the president has a parallel power to declare war. In the 18th century, if you started a war, you had declared it. As an English prime minister said in the early part of the 18th century, of late, most of our wars have been declared from the mouths of cannons and not by formal proclamation. They had a functional definition of declaring war. It could be a document, it could be a herald, it could be cutting down a flagpost, it could be scalping a person, and it could be just waging war. That's why Washington, Madison, Jefferson, Hamilton, and dozens of others said, the president can't take us to war, right? This was so well understood. It was well understood until World War II, right? Where we had 5 separate declarations of war against nations that had previously declared war against us. So that's all gone, right? By virtue of this sort of newfound presidential power to use military force overseas and thereby wage war. What about foreign affairs? There's a bunch of things I could say, but let me focus for a moment on treaties. In the 18th century, treaties were significant international contracts between nations. And in order to make a treaty, the president needed to get the Senate's consent, a 2/3 supermajority. That makes it difficult to make treaties. The House has no role in making treaties, even if they may have a role in implementing them. Flash forward to the 20th century, we now have treaties being made by the president without the 2/3 support in the Senate. Sometimes this is done with a bill passed through both chambers by simple majority vote. Think of Nafta. Nafta is an international treaty that the president could make pursuant to a statute that basically blessed the treaty that he wanted to make with Mexico and Canada. this isn't a question about whether NAFTA was a good idea or not. You can judge that for yourself on the merits of the particular, forms of the treaty. My point is the president has essentially acquired a means of bypassing the 2/3 requirement by going to the House and the Senate and getting a simple majority vote. This may not seem like a momentous thing, but it obviously makes it easier for the nation to make international agreements. You may favor international agreements, you may disfavor them. But my point is, if he can do this, what else can't he change? Or what else can he change in the Constitution? And the final thing I'll mention with respect to change is the president's relationship to law execution. Presidents mostly execute the laws faithfully. That is, their administrations mostly do a good job of trying to make sense of the statute and not trying to misinterpret it in some way. But where statutes run up against the president's agenda, or the president's heartfelt policy concerns, those statutes often get twisted in various ways. They get minimized, they get maximized, they get ignored. So let me give you some examples of this. During the financial bailout in 2008, or what was it called, the Great Recession, Congress passed a bill to bail out financial institutions. The House passed a bill to bail out auto companies. The Senate would not. George W. Bush decided, I'm going to bail out the auto companies using the statute for financial institutions, even though I don't think GM is a financial institution. And he bailed out Chrysler as well. Barack Obama continued that. They both basically violated the constitutional prohibition against taking money out of the Treasury without an appropriation, because there was no appropriation for the auto bailout. Let me give you another example, this time from the Obama administration. The Obama administration successfully passed the ACA with the help of Congress. There's a provision in there that authorizes but does not appropriate funds for insurance company subsidies. The Obama administration went to the Republican Congress and said, give us some money for these subsidies. We need them to make Obamacare work. The Republican Congress, rightly or wrongly, said, no, we're not going to give you the subsidies. The Obama administration then pivoted to the argument that the statute actually did grant an appropriation for the insurance companies and just paid out the insurance company subsidies from this supposed appropriation. Let me give you a final example that's more familiar to some of you, the wall. The wall, right? President Trump got $1 billion or so from Congress for his beautiful wall that borders Mexico. And he didn't get as much as he wanted, so he relied upon some statutory authority that in some limited circumstances allows him to transfer money from one purpose to another, I think Defense Department funding. But he had to declare an emergency, and so he declared an emergency. To me, this is a sham emergency. There is no emergency. If Congress passes $1 billion for your wall and on the same day you declare an emergency to transfer more funds, that's not an emergency. That's just you deciding you want more funds. He has good company with these sham emergencies. Every modern president has declared these emergencies in contexts where none of you or I would think there was an emergency. They're just basically saying, I think this, I should be able to access this authority or could continue accessing it by saying there's an emergency. And oftentimes the rest of us don't care because it's maybe a good idea to access the funds. But whether it's a good idea or not, it's not an emergency. There's now a common law of emergencies. If you ever go to Congress and they say, we're only going to give this to the president if he declares an emergency, you need to understand that that's a meaningless term, that the president can do whatever he wants. How did we get to this situation where the president has a parallel power to declare war? He can basically circumvent the treaty clause, and he no longer faithfully executes the laws, at least when they run up against his policy platform or his perception of national needs. I think we got there through a confluence of events. I list like 8 or 9 factors for why we have this. Let me just highlight a couple because I think I'm going on too long and I want to take your awesome questions. One factor I think has to do with our changed conception of the presidency, right? Presidents used to run for office on their resumes if they ran at all. They didn't make a bunch of promises. The first promise I found was a promise not to run again, coupled with a condemnation of the practice of making promises. They thought it sort of, corrupted your sense of what you ought to do in the office if you made a bunch of promises, because once in office, you might find that the promise shouldn't be followed, right? The policy dictated another outcome, but you felt like you had to satisfy the promise because you had made it. Today, no one runs for president saying, I'm going to make the trains run on time. Everybody runs to be president based on a bunch of promises. They have, they may not have much specificity, but they run on promises. Right? I'm going to make college free. I'm going to lower your taxes. I'm going to raise taxes on the rich. I'm going to withdraw from all these wars. Right? There are all sorts of promises being made. That has a corrupting influence on the president because it turns out he doesn't have the wherewithal to satisfy these promises. A lot of these promises turn on what Congress will do, and as we know, Congress doesn't always gratify the president's wishes and endorse his platform. The Republicans wouldn't give President Trump any dollars for his wall. It only happened once the Democrats came into power in the House. The light has gone off in my office here. I'm going to just turn it back on. Maybe it says something about what I'm telling you, but hold on a second here. There we go. Another change in our conception of the presidency has to do with, the idea that the president has an electoral mandate, which is itself a function of the idea that the president is elected by the people. As many of you know, the Constitution does not require a popular vote to select electors. Well, if you don't have a popular vote to select electors, you can't have an electoral mandate. That electoral mandate idea is an artifact of the 19th century. It did not exist in the 18th century, in part because over half the state legislatures chose the electors themselves. And so how could it be said that the people had endorsed any particular platform? Another change is the rise of political parties and the fact that the president is the chief of one of those political parties. This predictably weakens Congress in interbranch disputes. Why? Because 40 to 50 to 60% of Congress is predisposed to side with the president, especially on matters where the party has a stance. If a Democratic president takes some action with respect to abortion, Democrats will support it almost without regard to whether it's legal or not. If a Republican president takes some action with respect to, abortion, anti-abortion stuff, the Republicans are apt to support it almost without regard to whether it's legal because it advances their party agenda and their preferred policies. So while the founders thought that Congress would check the president, in fact, a good portion of Congress is cheering the president on. And it's not just because the president reflects the party platform or implements it, it's also because the public expects members of Congress to support the party chieftain, right? The president is far more visible than any party leader in Congress. And the party faithful are more apt to rally around him or her than they are anyone else in Congress. I'll mention one last thing, and it sort of spawned the title of the book, the idea of a living constitution. If you believe that the Constitution's meaning can or should change over time without any change to its text, if you believe that with respect to Congress and say the Commerce Clause, as Franklin Roosevelt did, he said, why should we be tied to a horse and buggy conception of the Commerce Clause? If you believe that's true for the Commerce Clause or you believe it's true for individual rights, why would it be less true for the presidency? And so I think, one of the natural consequences of thinking that the meaning of the Constitution ought to change over time is that, of course, the meaning of Article 2 will change over time. And as compared to Congress or the courts, the president is the 800-pound gorilla when it comes to constitutional change. He is able to create new practices, enunciate new conceptions, appoint allies to the court. And so he's best positioned to take advantage of the theory of the living constitution. And that's why we have the living presidency that we have today. So I went on a little bit longer than I had supposed, but thank you for your patience, and I welcome your excellent questions.
Okay, so I know Vic has to maybe duck out to put out some fires somewhere in a little bit, so we'll let him ask his questions first. Vic?
Thank you, Jason, and thank you, Sai. First, just a comment about one of the developments you mentioned a moment ago, namely the popularization of presidential selection. The demise of the way the Electoral College was originally operating, with the state legislatures picking electors themselves in this, move towards popular election. I was struck by the two cases that came down in early July involving so-called faithless electors. I wrote a couple essays, I think I'll forward them to you, that they commanded a unanimity, and that they were so non-originalist in their reasoning. Kagan wrote an opinion saying it's okay for states to punish or replace electors who don't do what the people expect them to, because that's what it means to appoint electors, as if appoint connotes subservience. We don't think that way about judges. We don't think that way about senators who are appointed by governors under the 17th Amendment temporarily, et cetera. And then she said there's no text suggesting that the electors are independent, when the only other two places the word elector is used in the Constitution are for voters of the House and voters of the Senate. And who in the world would think that a state can tell a voter how they have to vote when they vote for a House member or a senator? And then when it came to history, she pointed out that, well, there's been a history of pledging to support the person that the voters selected. And that history only goes back to 1900. So for the first, more than half of the country, there were no such pledges. But the history of attaching legal consequences to the violations of those pledges really goes back only till 1960. So she said a history in the last 60 years swamps the independence that electors enjoyed. And yet everybody, even, Thomas and Gorsuch and Alito, they all signed on, if not to that opinion in the case of Thomas, to that bottom line. So that's kind of an illustration, I think, of your point of how our conception of the presidency has really changed with regard to the election. But as I say, I'll send you a couple of these. And I think there are other easier ways to deal with faithless electors that wouldn't have required saying such kind of not ahistorical, atextual things. Giving power, instead of giving it to the political parties, give it to the two campaigns. Part of the problem with the electors is, they come from all wings of a party, and they may not really like the ultimate standard bearer. But there are other ways we could do that. But I just wanted to ask kind of three quick questions about your earlier remarks. One, you pointed to Truman and Reagan and Obama and Trump with regard to the power to use military force. I'm wondering what your thoughts, since Jason introduced this at the outset, I'm wondering what your thoughts were about President Lincoln's use of force to respond to the South while Congress wasn't in session. Is there, if not a power to declare war, and the president originally, is there a power to punch back when needed, especially if Congress hasn't yet had a chance to consider things? And the fact that Congress kind of affirmed Lincoln, was that okay in hindsight? Second, you talked about the take care power. And I agree that obviously there are instances where the president is, making law unto himself by spending money that was never appropriated, et cetera. But maybe a few words by you about the converse disinclination to enforce laws to the hilt. So certainly when a president thinks that law is unconstitutional, he has the power, and I would argue the duty, not to enforce it. But even when it's a policy disagreement, maybe at least in the criminal realm where he has the background power to pardon, maybe he doesn't have to send people to jail only to pardon them. So maybe say a few words about DACA. And if the president can refuse to enforce in a given instance, is there anything problematic about categorically telling the world, I'm not going to enforce in these instances, recognizing, of course, that I could change my mind or a new president could come in? Because I honestly don't understand why, if it's okay not to enforce in a given case, why it's not also okay to say, these are a category of cases I'm not going to enforce in, as Obama did, for example, with medical marijuana in states that had decriminalized it. And then the third point I guess I'd make about the emergency power, and you called it a common law of emergency power, except that technically there are these federal statutes that Congress has passed, the Emergency Powers Act, and the problem is that they don't define emergency. So the president can say anything fits within this very capacious statutory definition. And so and maybe you talk about it in the book, I haven't had a chance to get it yet, but obviously one problem here is that of overly broad delegation by Congress to the president for a variety of reasons. And, this past term or two, we've seen, 4, maybe 5 justices who want to go back to breathe some life potentially into the non-delegation doctrine. So I want to see what your reaction is to those 3. So Lincoln, DACA and non-delegation doctrine.
So this is great, Dean Amar. The electors point, I completely agree with you. I wrote a piece on the Wall Street Journal I'll send to you. It came out the day before the argument. I don't understand this opinion because it's just full of sort of ipsy-dixits about, of course they can do this. And so I agree with exactly what you said about the opinion. I think Lincoln had statutory authority to call forth the militia under the militia acts passed by Congress. What he didn't have authority to do was to spend funds not appropriated by Congress, and he didn't have authority to raise the army. And then finally, he didn't have authority to suspend habeas corpus. If you look at his July 6th, 1861 speech, he kind of admits that he didn't have legal authority to increase the size of the army or spend money. But he said, I didn't do anything that you couldn't have done. And I think he's basically saying that it was, it's this artful way of saying that I kind of understand I didn't do anything. Perhaps I did something wrong here. With respect to habeas corpus, he actually claims he has authority. He's very clear that he thinks he has constitutional authority. I think he's wrong. I wrote a piece called The Great Suspender, where I talk about the suspension power in great detail and how no one prior to 1861 ever thought the president could suspend the privilege of the writ. It was never suspended by any executive, either in England or in America. It was always done by the legislature. So I think he's wrong about that, but I'm speaking to folks in the land of Lincoln, and I yield to no one in my love for the man. But he can be wrong just like every other president. He doesn't have he's not infallible. He's just a great person. This DACA point, I agree with you and those who said that the president had prosecutorial discretion. I actually wrote a piece in the Texas Law Review online. I forgot what it's called, See Also or something. John Yoo and Robert Delahunty had written a piece criticizing Obama, and I wrote a short 10-page piece saying that they were wrong. The basic intuition is, I think as a matter of statutory construction, if Congress does not require that everybody be prosecuted for an offense, they're implicitly ceding some discretion to the president, and that he can announce categories of people he'll focus on. So I give the example of a sheriff who doesn't give you a ticket because you're going to the hospital. I think it's perfectly fine for the sheriff's department to announce this rule. And if the legislature disagrees with it, they can just say, you know what, we don't want you to have that discretion. The problem with our immigration laws is we have, upwards of 12 million people that can be deported and funds to deport, I think, about 400 to 600,000. In that context, and given, I think, a general background presumption of statutory discretion about enforcement, where the statute itself said the president or the attorney general could set enforcement priorities, I don't think the president did anything wrong. Having said that, it was a politically charged issue. He had said he could do nothing. And so people were naturally, quoting his words back to him. And, there is a sense in which, giving people a card that says you can stay in the country for 3 years and it can be renewed, made it look different than ordinary prosecutorial discretion. Now, there's a category of deferred action that had been relied upon by prior presidents. Statutes of Congress had referenced this deferred action. So there were things that that I think help support what the president did. As it turns out, it was more sticky than he said it was. He said the next president could overturn it, and I guess you can if you go through some more elaborate process. And then the last thing about emergencies, what I'll say is there are statutes which say that if the president wants to do something in his discretion, he can do it. And then there are other statutes that say if there's an emergency, the president can do it. And my sense is that those sets of statutes should be read differently. It's one thing to say that the president can do something if he finds it needful to do so. It's another thing to say that he has to declare an emergency. And you can draw the contrast that Marshall drew in the Constitution between necessary and absolutely necessary. An emergency strikes me as closer to the absolutely necessary mark as opposed to the merely necessary and proper mark. And if all that emergency means is you think it's a good idea, then there's no reason for this differential treatment. So while it's true that they don't define emergency, I think common sense dictates that it can't just be that you thought it would be a good idea. Because if that's all it means, they just would have said, do you want it, you should do it whenever you feel it's appropriate to do it. And there are statutes that say that. So these were wonderful questions. I'm sorry that you have to go, Dean, but we'll connect later.
Thank you. So we're getting some questions in the text box, but I have a quick one that follows on from Vic's question. And I just wanted to ask you about maybe sort of the framing of the problem. And instead of the living presidency, I wonder if it's a case of the enabled presidency, in the sense that a lot of what you describe, I think, is not so much the president grabbing power, but Congress stepping back or affirmatively handing authority over to the president. Is that a significant part of your story?
Well, I don't think it's just the case of, so I do talk in the book about delegations, and I do talk about the Chevron doctrine. Delegations are clearly Congress passing a statute saying we want you to handle some area for us, right? Rather than us creating detailed legislation. So there you could say it's Congress enabling. If you look back at the history of the Korean War, there were people who said, what are you doing? You don't have the authority to do this. Now you could say that they enabled him by not, impeaching him or not censuring him. But there are a lot of considerations to take into account when a president starts a war that many people might have supported. And they don't want to necessarily censure the president for starting it unconstitutionally. But you hear this claim of the president acting unconstitutionally in prior wars as well. You hear about it in the Mexican-American War. You hear about it from Abraham Lincoln. Right? Abraham Lincoln actually introduces resolutions criticizing James Polk for starting that conflict. So I don't think it's the case that most, much less all of the things I'm talking about are Congress enabling the president, right? So the auto bailout is not Congress saying you can bail out whoever you want to. It's just Congress saying, the House saying please bail them out, and the Senate basically not being able to, quote, get its act together or pass a bailout, and the president just doing it. I don't recall if Rand Paul criticized it. I don't recall who criticized it. I didn't do any research on that. But they don't have to criticize it in order for someone to look, looking at the episode, to say that the president has assumed authority, right? It's one thing to be silent. It's another thing, as you would point out, to affirmatively authorize it. And then in the case of the insurance care subsidies or the wall or DACA and DAPA, you have members of Congress pushing back. And the problem is that because Congress is driven by partisanship, it's very difficult for Congress to agree upon anything. They can agree upon principles in the abstract, like the president shouldn't spend money without an appropriation. But when it comes to an actual controversy, they can't avoid focusing on what the money is being spent on. And if they favor it, they just typically fall silent. That's less true for the wall, in part because a lot of Republicans don't favor it, right? There have been Republicans who've said that this was this was an illegal act of the president. He can't just decide to transfer money around because he says there's an emergency. But I haven't looked to see who these people are, or more precisely, whether they oppose the wall on policy grounds. But if the president does something in service of a party platform, it is very rare for co-partisans to oppose that president. So there is some enabling going on, but there's also some usurpation going on as well, I would say.
Good. So we have a question that goes back to Lincoln, and it actually ties into a part of your response. So the question was essentially, is Lincoln breaking new ground, or were there presidents acting in ways prior to Lincoln that sort of created a precedent for some of the things that Lincoln may have been criticized for?
Well, there is no president who previously suspended the writ of habeas corpus. Right. Lincoln doesn't cite any president who spends money without an appropriation, although I think there are some people who said it happened, albeit in a context where Congress, say, authorizes a conflict, but doesn't appropriate the funds, and the president assumes that there's authority to incur obligations, even though there's no funds appropriated for the war. And then the size of the army, that's always been done by Congress. I don't know of any previous example. Look, I think Lincoln found himself in a singular position. Congress was not in session. He had to act. He had some statutory authority, but not authority to raise the army or to spend money or to suspend habeas corpus. And he did what he thought was necessary. He could have just said, I acted illegally, but I had good reason to do so. And why don't you just, why don't you just ratify it ex post? I think he basically does say that with respect to the army and the appropriation. He does not say that with respect to habeas corpus. The interesting thing about Lincoln is he does cite Jackson, but he doesn't cite President Jackson. He cites General Jackson. Yeah. General Jackson suspended habeas corpus, and lots of Democrats supported this ex post. Lincoln was a Whig. He couldn't have supported this, but he cites it to show that Democrats aren't being consistent because Democrats are criticizing him for suspending habeas corpus, and he says, but your torchbearer, your party, your flag bearer, Andrew Jackson, did the exact same thing. So this, I think, inaugurates the practice of whataboutism, executive whataboutism. In every modern dispute about presidential power, the president's co-partisans and the president's lawyers go back and try to find some analogous situation where they say, see, this person did the same thing. And sometimes it's right on point and sometimes it's not. But it doesn't necessarily come to grips with the legal question, because you might have the view that just because someone else did it doesn't make it legal. That's certainly the theory of the book. That's not the theory of Justice Frankfurter.
Could you say something about the executive branch as distinct from the president as an individual in terms of sort of the expansion of power in that branch of government? I mean, how much of what you're describing is done by the president versus all of those hundreds of thousands of people in agencies working under the president in ways that I suspect the president cannot easily oversee and control? How much of that is driving the expansion of the presidency or the executive branch?
I think that is definitely a factor. It's mentioned in the book. The executive branch bureaucracy, particularly the portion dedicated to defending the president's prerogatives, is rather large and ever growing. The Office of Legal Counsel, the White House Counsel, the Office of Legal Advisor in the Department of State. All these folks have a fairly aggressive understanding of executive power. And they're all funded by Congress, right? And so Congress is basically assisting in the expansion of executive power in multiple ways. I think you're quite right, Jason, that this actually redounds to the benefit of the bureaucracy, sometimes more than the presidency. There are opinions of the Office of Legal Counsel that talk about presidential authority, say to, send delegations to some UN panel where the president himself is not interested in the UN panel at all. It's the bureaucracy, the State Department bureaucracy, that cares about the issue. And so the OLC writes up something and the State Department cheers it on, and the president signs it, but it's not as if the president really cares about who's going to this, this entity run by Iran, where Congress has declared that we can't send delegates to this entity. So what I say in the book is the bureaucracy's power is parasitic in part on the president's constitutional authority. And so it's not surprising that some segment of the bureaucracy favors expansive presidential power, because they gain by having a more powerful executive branch, at least in some respects. It's not true with respect to every issue, but it's true, I think, over the run of the issues.
Good. So if there are audience questions, just keep typing them in the box. Otherwise, I could just keep asking you questions, Sai. Here's one. Question about, so understanding of the general welfare clause. This is power to tax and spend for the general welfare, and sort of your understanding of the scope of that. This is, of course, in Congress's list under Article 1, Section 8.
This is a great question, Shyam. The book does not talk about the general welfare clause of Article 1, Section 8. I'm sympathetic to Madison's position. I think perhaps that Hamilton was wrong. You, of course, know, and others know, that the courts have essentially adopted Hamilton's position that there are no, subject matter constraints on what Congress spends money on. But I haven't given the issue systematic thought or research. So it's a very interesting question, but it's sort of orthogonal to the book. The book is partly about Congress, but not discussing this particular question.
Okay, and Vic is up next. He's still here. We couldn't get rid of him.
Well, I went away for a little while and came back, but I heard the volume. So you haven't, as far as I can tell, directly invoked the notion of the unitary executive and what that means for any of this. I mean, Jason's question about the administrative state kind of got at that a little bit. I was actually quite intrigued with the background comparison to monarchy that you laid out, and the distinction between kind of a unitary monarchy and a kind of a multi-head or pluralistic monarchy. And it made me think about this last term's case involving the pension benefit guarantee. I mean, the Consumer Protection Financial Bill, the SELA law versus the CFPB, because Chief Justice Roberts wrote that opinion in such a way, I think, as to deflect attacks on the Fed or the Federal Trade Commission, these multi-member bodies that are independent. Adrian Vermeulen and Cass Sunstein wrote an op-ed in yesterday's New York Times that I think made no sense, to be honest, because it ignored that clear effort by John Roberts to do that. But it seemed to me that Roberts' opinion really leaned heavily on the fact that the CFPB was run by a single individual and not multiple people, the way some of these other so-called independent agencies are. I was wondering what you thought of that reasoning in that case, and your thoughts more generally on the direction the unitary executive theory is likely to go or should go.
So that's a great question, Dean. The book doesn't talk about that, except to say that the restrictions on the president's power to remove various officials in what I would call the executive branch are suggestive of congressional, backbone and spine to push back if necessary. That is to say, this is an area where I think Congress has pushed and gotten its way to some extent. I actually think it's Congress acting unconstitutionally, but I cite it not for the proposition that it's constitutional, but for the proposition that Congress certainly can push back. And of course, you can cite Watergate, the post-Watergate reforms, the slew of post-Watergate reforms as another example of congressional pushback. As for what the court's likely to do, I share your view that I think the court or the chief is setting up perhaps a future case where the court will revisit Humphreys and perhaps overturn it. What we're referring to here is the idea that Congress can create multi-member commissions and grant them authority to execute the laws, but also engage in rulemaking and some adjudications, and grant the commissioners of those agencies so-called for-cause protection, meaning the president can't fire them at his pleasure, as he can, say, the Department of Defense Secretary, the Attorney General, the FBI Director, et cetera. So I do think that, the chief, I think, has long been an acolyte of the theory of the unitary executive going back to his days in the Reagan administration. I think his opinions reflect this. I guess he did not feel the need to overturn Humphreys in any of these cases. He's just distinguishing the case repeatedly. But it's possible that in a future case, he's able to look at the body of law and say, this no longer makes any sense. That's one of the factors that you look at in terms of, stare decisis and the effect that stare decisis has or precedent has on a future case, and just say that there's a hodgepodge here that isn't coherent, and so now we're just going to start from square one and decide whether or not to honor these statutes that grant a for-cause independence. So I think you're right. I don't know if he'll have 5 votes when he gets around to it. I think it's playing for the long run in a context where you have no idea what's going to happen the next year. So, I guess that's probably what he's doing, and he's just being, I think, ultra patient about it. there obviously are other justices who would overturn Humphreys. I think there's probably 3 or 4 votes, and he would be, I think, one of the swing votes. The weird thing is about these rules. My friend Neil Devins has argued, and I think shown, that eventually the president does acquire control over these independent commissions in the sense that he appoints a majority of the allies. So all that this does really is it just shifts presidential control to an asynchronous period, right? Rather than the president having immediate control of the FEC, it takes 2 years, and then his control typically extends into the next administration. And even that's not as true as it used to be, because a lot of people don't serve the full 4 or 5 years, meaning, you could have immediate control from day one if you're able to appoint allies and get them through the Senate. So I think the rationale for this no longer even makes any sense, right? No one thinks that the FEC is any more expert than anyone else, or that it's apolitical. Because typically they're appointing the president's allies or allies of the opposition party in Congress. So I think, as you said, it's right for the court perhaps overturning it.
It's interesting that, as you were talking, I was just thinking about justices who have disappointed the president who did the appointing, and how they may drift. But I think maybe the mindset of someone appointed to the judiciary is somewhat different than to an executive branch. And the time period, as you pointed out, even people like Harry Blackman or others who kind of changed their views relative to the backdrop, it took time to do so. And if these people aren't serving very long, then you're right that the president probably has a lot more control. I'm going to ask one more if there's no one in the queue. This is a little far afield, but I read an essay in the Atlantic, I think, a few days ago by Jonathan Chait, laying out the case for prosecuting President Trump after he leaves office, should he lose, and should there be evidence of criminality that comes to light. And I'm just kind of wondering what your sense of we've to my mind rightly refrained from visiting harsh justice upon former presidents, whether or not there was a legal criminal case to be made. And as I say, I would like to, my own instinct is to kind of preserve that tradition. But I'm just wondering what effect you think it would have on the presidency and presidential politics if there were kind of an after the fact big attempt to use the criminal process. The way President Trump, during the campaign in 2016 argued, should be visited upon Hillary Clinton
right
in her life. So this is not a partisan question.
Yeah, of course not. I don't think that Joseph Biden will allow his Justice Department to prosecute the president, because his presidency will immediately be about Trump again. Yeah. It's just a bad decision, a bad use of his time and resources to be focused on Trump for 2, 3, or 4 years. So I just don't think he will do it. Now, state prosecutors could, because they don't have the same incentives, right? Right. And there's nothing that, to my knowledge, that the president could do to prevent the New York, district attorney or the attorney general from prosecuting the president.
Can Congress immunize former presidents from state criminal prosecution?
That's a great question. I think it would turn on whether you think it's necessary and proper for carrying into execution some federal power.
How about the power to take care? Because presidents may be too shy in enforcing the law if they think some particularly partisan DA in some part of the country will make their life hell after they leave office.
Look, I think your intuition is right that the court, I think, has suggested in Clinton versus Jones that Congress could have given Clinton some immunity, temporary or otherwise, certainly temporary, from those state suits. So I'm open to the idea. Of course, and this is just as a matter of law, not as a matter of policy, if the conduct relates to his private conduct, you might think it's odd to say if you don't give him immunity, if you don't find it in the Constitution, or if Congress doesn't convey it, it would affect his duties as president. Now it might, because you might think you're more likely to be prosecuted for your private offenses because you didn't gratify the prosecutor.
Although that very plausible suggestion you just made didn't seem to have much traction to the majority in the Vance case, going after the president's records. I mean, that was basically part of the argument there, that if you empower DAs like this, they're going to do it for all kinds of partisan reasons. And the court didn't. I mean, the court said, "No, we're not really worried about that." It was very similar to Clinton versus Jones. Trust state law, trust the judge, trust the grand juries, et cetera. And I thought, well, we kind of went down this path before, I thought.
I think you're right. On the other hand, they do talk about, bias or harassment and other things. So they say, there's two cases, right? There's Vance and there's Mazars. And in Mazars, they're more wary of Congress than they are of state prosecutors. So
which is ironic, I think. Which I thought going in, that's a bit ironic, that we trust the states more than we trust Congress.
It is. It's very odd. But they don't quite say that there's no special protection for the president. They do imply that the president is entitled to some special consideration, and they talk about harassment and other sorts of things. They're not willing to create a per se rule that criminal process can attach to the president, state criminal process. And they're not willing to, apply some other higher standard. Instead, they're happy saying some sort of generalities. And at one level, the president lost, but at another level, he's still making these arguments about harassment and political vendetta in New York. And, the district court waved it all off, as you may know. But the circuit court has stayed the district court, dismissal of the case, I guess.
Yeah. And
they're now going to hear arguments about, whether this is a political, witch hunt and whether the person's harassing him or not, whether Cy Vance is harassing the president. And then I expect this will go back up to the court, or more specifically, the president will seek review if he loses, and so will Cy Vance if he loses.
Although if Biden wins, maybe it'll all go away, and we'll never know what the Second Circuit, maybe Vance.
I think you're right, but as you look, Cyrus Vance can make a name for himself and protect his left flank if he prosecutes a former president named Donald Trump.
Yeah.
Right, and so it's crazy to think that prosecutors are less partisan than Congress. Most prosecutors are going to run for another office. That's not their last stepping stone.
So can I ask you on the Biden example that you talked about a moment ago? So you're perfectly comfortable with a future President Biden directing the Attorney General not to proceed with a prosecution of a former president?
Well, I mean, we know he can pardon, so
right.
There's no doubt about that, right? Something short of that, yeah. I mean, George Washington told district attorneys not to prosecute. We've had that practice going back to the Whiskey Rebellion. So I think it's totally constitutional. You can disagree with it on the merits, right? And people could say this is a bad thing for the rule of law to have the president tell his attorney general not to prosecute someone. But Trump was smart enough to realize that he wasn't going to be helped by trying to prosecute Hillary or reopen that investigation. He quickly said, we're not going to bother with this. I don't even know if he had any intention, right? That was just probably just a slogan he was just going to rile people up with, right? And, I'm sure there are people now saying lock him up about the president. And that, I don't think Biden is doing, because I think Biden's sort of, generally more responsible than in his rhetoric than the president, generally, but not always.
And also, of course, Biden's main theme is he's a unifier. So, he certainly can't say that going into the election. And if he does a 180 right after, that would be very hard. But you made a good point I just want to reinforce, Cy, and that is, with all the talk in the past 2-3 years about the relationship between the president, the attorney general, the DOJ, the FBI, the reality is the president sits atop the criminal justice apparatus of the executive branch. And there are questions about what was wise, what is in keeping with tradition, in terms of how much to kind of meddle in prosecutorial decisions or personnel in the DOJ. I mean, I used to see articles about how the DOJ thinks one thing, but the FBI thinks another. And I thought the FBI was part of the DOJ last time I looked. So, it's just, we really lost the distinction between what is constitutionally permissible versus what is kind of out of keeping with, recently entrenched traditions.
Yeah, that's right. I mean, I think a lot of people believe the president shouldn't be enmeshed in particular prosecutorial decisions. And I think if you're the president, you don't want to be, because you're going to be constantly bombarded with requests to intervene. You're not going to have a full sense of what's going on in these cases. Presidents, I think as a matter of constitutional law, the president's the chief prosecutor, but a lot of our presidents aren't lawyers, and so it's a bad idea for them to try to get involved in that way. It's another thing to say, look, I just think this person has served enough time, I'll pardon him or her, right? That seems appropriate to me. You don't need to be a lawyer to have a sense that perhaps some people have served long enough. There's a separate question of whether it's fair to, dispense justice on sort of an uneven basis when you're,
Right. But go back to Hillary Clinton, though, your point. If Trump had come into office and there was still a lot of momentum to go after Hillary Clinton over the emails, and Trump said, I'm directing my attorney general to cease and to even if the investigation is still ongoing, I'm killing this investigation now because I think it's better for the country to move forward. People might disagree with that decision, but no one would say the president doesn't have the power to do it. This is all about why the president does what he does or she does in a given case, not whether there's the authority there. And I think we've lost sight of that important distinction.
I think you're right, but when people think about these questions in concrete situations, it gets twisted by virtue of those concrete situations, right? So, there are, I think the fact that, it was DACA and DAPA and Obama led some conservatives to think, oh, you can't have a policy of non-enforcement, even though it's clear that we have many laws that aren't being enforced, in part because we have other laws that prosecutors think are far more important, right? Or they may not charge you with multiple crimes for an underlying action because they think these particular crimes should be charged and they provide sufficient punishment. And no one says, oh, you need to charge every single, I don't think anyone thinks you have to charge every single crime that's possibly justified. So people's sense of the law obviously gets perverted in the context of partisan disputes. I think, I'm thinking back to what Jonathan Haidt said in one of his books. He says, sometimes we just ask the question, not whether it's right or wrong, but can I believe it? Can I articulate this argument consistent, with my sense of myself? And too often people are willing to just say, like, I don't really care whether the presidency writ large can do this. I know that in this particular context, it helps my partisan affiliation to say the president can or can't. And I might very well flip, right, in 4 years. And hopefully no one remembers my position 4 years ago. But it's not really based on some deeply considered view of what the president can or can't do. There's some consideration of that, but also some consideration of, well, does this advance my agenda? And can I make a plausible argument for believing this versus that? And the answer is, often yes.
Can I ask you a question then in a different context, but I think that continues on from this point? It's a question about our current pandemic and the coronavirus. Every day we see in the news reports about how many people wouldn't have died had President Trump done certain things earlier on or done things differently. Now, I gather that from a sort of 1789 perspective, the idea that the president would be sort of mounting the response to a disease wouldn't have been seen as part of the president's authority. But I wonder, is it a reflection of the sort of cultural permeation of this living presidency idea as you've presented it in the book, or is it even a step beyond that? And it wouldn't have naturally occurred to me, for example, that even given all the powers of the presidency today, that the president would be the one responsible for playing the leading role in directing the response to a disease outbreak. Are we sort of even beyond the sorts of issues that you identify in the book?
Yeah, Jason, that's a great question. There actually was a plague in Philadelphia in the early 1790s. It was the yellow fever plague and thousands of people died. And there was a question about presidential authority, but it was a very narrow question. The question was, could the president summon Congress to a place other than Philadelphia? The president has authority under the Constitution to summon Congress, right, on extraordinary occasions. And what he wanted to do is say, let's meet somewhere else so you don't come back to a plague-infested city. And he got all kinds of opinions. And most of those opinions said, no, you can't do this. You have authority to summon them early, but not summon them elsewhere. So they set upon the expedient of just the president summoning them, but telling him, I'm going to be somewhere else for this reason. Perhaps you should meet me there. I think it was Germantown. And that's what he did. And I think, you know, there are other episodes from early administrations where presidents deny that they have any emergency authority, right? I mentioned Andrew Jackson suspending habeas corpus and declaring martial law in New Orleans. You know, James Madison says that that's unconstitutional. The executive can't declare martial law. So I think there's a consistent pattern of denying that the executive has some broad emergency power. I think you flash forward today, and I think what you're seeing is a combination of two things. We have great expectations for our presidents. We expect them to solve all manner of problems, right? I have a discussion in the book about livable communities. Why is there a discussion about livable communities? Because Al Gore ran on a platform of having livable communities. And presumably he said that because there were people in his coalition that liked the idea of livable communities. I'm for livable communities, but it hardly seems obvious that the federal government, much less the president, has any authority over that. So, you know, I think people see the presidency and they see this really powerful office, and they expect that the president will have something to say and do about the pandemic. And it turns out the president has some authority, right? With respect to travel, like overseas travel, he has some authority, right? To prevent people from coming into the country. And he probably has other sort of statutory authority. And I haven't sort of looked at it all, but he clearly doesn't have, to my mind, carte blanche to do whatever is necessary to you know, stem the coronavirus epidemic. But we have a living presidency, and just because he doesn't have it today doesn't mean that his successors won't acquire it. So imagine a counterfactual. Imagine President Trump really wanted to be aggressive on the pandemic. He doesn't want to. He wants the economy open, but imagine he wanted to be aggressive. He would have done certain things. Certain people would have pushed back, but he would have created a practice. The next president, if he wanted to do the same thing or she wanted to do the same, would have cited Trump and say, see, that he did it, and so I can do it too. And that's in part how presidential power accretes. That explains a lot of the accretion that I've already discussed in foreign affairs and in war powers. They just cite what happened before. And then 30 years later, we have a different conception of the president's powers in pandemics. So while we don't think, I think, while you know, educated lawyers don't think that the president has some generic emergency power to deal with pandemics, that conception doesn't need to be static. There's nothing preventing the president from acquiring more authority, just as he's acquired it elsewhere. So one of the arguments in the book is there is no natural stopping point to presidential power. Because if you had asked me as if it granted the president authority to wage war against foreign nations, he would have said no. That's ridiculous. But here we have a Office of Legal Counsel that makes the argument. And so there is no, you know, natural boundary, right, that limits the, you know, maybe the United, you know, there's no natural boundary, geographical boundary that prevents the president from acquiring new authorities, including pandemic authority.
Well, great. On that point, I think we've come to the end of the period. I know people have to go to classes. We could, you know, keep going on this discussion, I think, for many hours. And we thank you so much, Sai, for speaking with us today. This is just extraordinarily interesting. And maybe we'll want to touch base with you after the November election and hear some more thoughts from you at that point. And certainly we hope to welcome you back in person to the University of Illinois when it's safe to do so. But this has been really wonderful, and so thank you.
Jason, I want to thank each and every one of you for making the time today to listen to my chat. And I want to encourage each and every one of you to get a hold of this book. Operators, as I said, are standing by. And as Jason said, it's a delightful Christmas book. It's readable.
Oh
It's
yeah.
not,
Oh yeah.
you guys are lawyers, but it's it's made for ordinary Joe and Jane citizen to read. So it doesn't need to be for lawyers. Thanks so much, guys.
Perfect. Thanks, Sai.
Take care.
Bye-bye.